All right, we're good to go.
Excellent, thank you. Good morning, everyone. I apologize for being a few minutes late. We're just settling in. We need to take a roll call because we're holding this meeting of the Massachusetts Gaming Commission virtually. Good morning, Commissioner O'Brien.
Good morning, I'm here.
Good morning, Commissioner Hill.
Good morning, I'm here.
Good morning, Commissioner Skinner.
Good morning.
And good morning, Commissioner Maynard.
Good morning, I'm here.
Excellent. Well, happy Valentine's to everyone. It is a beautiful Valentine's Day on February 14th, 2023. Public meeting number 435 of the Massachusetts Gaming Commission. We've got some good work to get going. So I turn to Executive Director Wells. Thank you.
Hey, good morning. So for this morning's administrative update, I just wanted to make a staff announcement that we are starting to round out the sports wagering division. So Sterl Carpenter has been placed in the position of sports wagering operations manager, and Crystal Boschman has been put in the position of sports wagering business manager. So Bruce, I know you're very grateful to have the help and very happy to have these two superstars on the team. So just wanted to make that announcement publicly, and they will be working with Bruce on all aspects of the sports wagering division. So that's it for the update. We can go ahead to the next item, Madam Chair.
Well, I need to just pause and congratulate Sterl and Crystal. These are two new positions, and they're exciting positions. Sterl, I know that you've worked with Bruce all along, and what an asset you are. And of course, Crystal has really been the right hand and more for me. It is a great promotion for Crystal, and I know that the Gaming Commission and the Commonwealth are benefiting with this promotion. And Crystal knows how much I am going to miss working very, very closely with her. That transition is occurring in real time. We'll try not to bug Crystal too much, but Karen and I and Crystal are ironing out those details. So, Bruce, you got the best.
Yeah, thank you. I'll believe it when you totally give her up over to here.
Well, I'm totally giving her up, but she's of course the professional that she is, and is helping out. But we want to hand her over and so that you can have her to your entirety, Bruce. But it's all very, very good for the commission, and congratulations, Sterl and Crystal. It's wonderful news.
Yeah, I got two of the best.
Yeah, excellent. Okay, so we're turning now then to IEB, and I see Enforcement Counsel Heather Hall. Good morning.
Good morning, Chair. Good morning, Commissioners, and happy Valentine's Day to everybody. So we are here in follow-up to our conversation last Thursday, and the IEB has conducted a review of a sports wagering non-compliance incident that occurred at Plainridge Park Casino. And that in terms of the incident of non-compliance generally, on February 3rd, 2023, PPC Compliance Manager Lisa McKenney notified Sports Wagering Director Bruce Vann that PPC mistakenly offered wagering on unauthorized events. The error was actually reported to PPC management internally by a PPC sportsbook writer. And just in terms of those who are still new to this, as am I, the writer is actually the teller who works at the cashier's counter. So with respect to more detail on this particular incident, on February 2nd, a regular season Merrimack College men's basketball game versus the Long Island University Sharks was offered for wagering. And upon learning of the error, PPC notified its sports wagering event system provider, Canby. And the IEB learned the following kind of key facts with respect to the incident. So the time frame for wagering was approximately 7 hours, from 11 a.m. to about 6:20 p.m. And the total stakes wagered, in follow-up to, I know, Commissioner O'Brien's question on Thursday, was approximately $6,848. The total winnings were approximately $4,270. And the number of bets placed were 33. And these were 33 bets across 27 tickets, or coupons as they're also referred to. And one of those tickets had seven distinct wagers on it. So that particular ticket involved more wagers than the others. In terms of the location of the bets, there were 4 bets placed at the cashier's counter desk, and the remaining were placed at kiosks. And as for the reported reason for the error, PPC manager, sportsbook manager Ryan Blake, and I just want to note that I think I might have misreferred to him as Black, so his name is Ryan Blake, reported to the IEB gaming agents that the error occurred because Canby mistakenly assigned the participant school state for Merrimack College as Florida instead of Massachusetts. So that allowed Merrimack College to bypass offering compliance filters, which were configured to block all regular season matches involving Mass teams based on their assigned participant school state. Canby reported that once they were notified, they corrected the error in approximately 10 minutes. Canby also, after fixing the error, further reviewed what had happened, and they confirmed that only Merrimack College was affected and that all other Mass teams in Canby's system were properly assigned as a Massachusetts school, and that no other games in Mass involving a Mass team were offered, including a Merrimack game actually that was offered for the next day. Canby also reported that it reviewed all of the bets for suspicious activity and did not find any. And with respect to remedial or mitigating information, PPC has reported that Canby did conduct a separate audit to confirm that all other Mass schools were properly coded in the system, and they were. In addition, Canby added a second layer of protection by essentially creating a blacklist or an additional filter for the NCAA bets in Mass that are not part of tournaments involving 4 or more teams. That filter is independent of the state location field listed in the system, and that will serve to block all local Mass collegiate teams from being available in the regular season without needing to rely on the participant school state as the sole filter. Canby also relayed that a line manager is going to follow up with the staff person who was responsible for the error, as well as the entire team, with regard to guidelines for the process for coding the participant states. In addition, PPC, PSI, and Canby provided MGC staff, and meaning Bruce Band's team, with a listing of all Mass institutions to which the prohibition should apply. Director Band has reported that the list was reviewed by MGC staff and verified as complete. And I also want to thank Sterl Carpenter. I know he's worked on this as well. And I also want to note, too, that in conversations and communications with North Brownsville from PPC, as I think all of you know, he's PPC's Vice President, General Manager, they have provided the list of the prohibited Mass teams to all of their sportsbook personnel. PPC instructed their staff, including the writers and sportsbook managers, to ensure that bets they are taking are authorized. So this is another added layer of protection. And they also relayed to staff that they could be disciplined if they allow a wager on an unauthorized event. PPC has also instituted a daily check to confirm that no prohibited Mass collegiate team wagers are offered in Canby's system, and that the manager who checks the daily list, they are actually required to sign off, attesting to having reviewed it and confirmed that no collegiate teams or prohibited wagers are offered. And I think one final note that is, I think, important is PPC has recognized and rewarded the team writer who initially identified and reported this non-compliance issue. And they relayed that the goal is to create a culture of commitment to compliance as the top priority, and to encourage their staff to promptly report non-compliance. So that is the update with respect to the PPC Merrimack College matter. I'm happy to go into the other matter as well, or we can certainly take questions however the commission would like to do it.
Heather, I think that I understand that you may be providing us at some point today insights on other jurisdictions, reactions to similar types of situations.
We can do that, Chair. Yes, I do have some information on that. We are, continuing to review that matter, but I definitely can give a preliminary insight that we have gleaned from our review of various reported noncompliance. So happy to do that whenever you would like.
Questions for Heather on this report. Then I would suggest she goes to the next report and then reports on other jurisdictions, if that makes sense. Mm-hmm. Okay. Commissioner O'Brien, are you leaning in?
I am. I had a question. Just Heather, the recitation you just gave, and you talked about the remedial measures the PPC took. I'm glad to hear they're lauding the teller who flagged it, because But then you made another comment about they're being informed that there could be repercussions if you allow a bet that's not supposed to be placed. So my question is, can a teller override the measures, the systemic measures that were just described? Because it would seem to me, I was under the assumption once those were put in place, there wouldn't be able to be a manual override to allow somebody to make a bet, but am I wrong on that?
That's a great question, Commissioner, and I can't speak to the specifics of that, but my understanding is that the teller would be required to notify a manager. And I'll certainly, defer to Bruce and Sterl to supplement with respect to that answer, but that was my understanding, is that, they're required to notify as it goes up the chain, notify the manager and let them know that there's an issue. And I also just want to reiterate that I also was happy to hear that they recognized that individual who did report it, because I do think that helps foster a culture of reporting issues so that, the goal of compliance is key there.
To follow up on Commissioner O'Brien's point.
Oh, Bruce, you're muted.
I'm muted?
No, Bruce was talking, but he was
Oh.
muted.
Oh, I'm sorry, Bruce. Thank you so much.
If it's in the system, they can't really override it. They
can't
just
override it.
cannot sell the ticket would be the.
Okay, that's what I thought. Okay, just wanted to make clear. Okay, thank you.
So a follow-up question for you, Bruce. Is it typical that the teller, if you will, or the writer would actually have the burden of that compliance? Is that
I think it's incumbent on any writer to have that, but to know all the schools, I think is a difficult thing for any employee at that stage, especially if they're really busy,
right?
With long lines. But that was a real heads up move on the one that did recognize the school. So,
Well,
and Chair, if I can jump in for a moment, I did just hear from North, who confirms that a writer cannot force a wager that is unavailable in the system.
They can't force it. I think the idea, can they fix something if they see a problem, right? If they can't override it, but they also
can't override it. I don't know if North may clarify. I don't know that I can't speak with certainty what happens.
So my concern is, I'm guessing what the answer is to that, Loretta. My concern is, and I may have misheard, and Commissioner O'Brien, did you hear Heather? And Heather, did you say that they're anticipating consequences for sort of line level employees like the writer if they allow it to go forward?
That is my understanding from talking to North, and I'll certainly allow him to supplement that. But I think the goal was to say, listen, everybody needs to know what these which wagers are allowed and need to be on the lookout for it. And with that, I will definitely turn to North, because I don't want to overspeak on their current process.
Hi, North. How are you? Good morning.
Good morning, Madam Chair. So quickly then, the writer cannot force a wager into the system that is unavailable. They also, I believe, Commissioner O'Brien, your question was whether or not they could fix a wager, like if they notice that there's one in there that should not be in there. They do not have the ability to make a wager unavailable. We would still need to coordinate with our with Canby to make that happen. However, Canby's been super responsive. If I found out that we had a wager that was unavailable like that, then there would probably, or one that was available that should not be, there certainly would be things that we would do to prohibit those wagers from being placed. With regards to the discipline piece here, I think it's more just a reminder to team members that we all have responsibilities to not knowingly violate regulations that are put in front of us. So this is a matter of saying all the team members have been provided with the full listing of Massachusetts institutions in which they are not to accept wagers. We do understand that people make mistakes throughout the course of their day, and it's always our desire to make sure that they have all the tools that they need in order to remain in compliance. But it's really more of a reminder of, hey, listen, we all have a role to play here in making sure that we remain in compliance. And again, when we have a team member who raises their hand and brings something to our attention, we want to reward and recognize them. So there is no intent here to lead with the stick of punishment. This is more an opportunity for us to just make sure that people understand their obligations.
And if I could just follow up, North, I think my understanding is that really where you want the compliance is you want it at the Canby level.
Correct. I mean, having
that's
a
where
correct.
it starts.
Yes, Madam Chair. So, I mean, obviously having a system that's correct is the first line of defense and the most important one. But we at the property level also play a role here in making sure that we remain in compliance. The same way we wouldn't knowingly pay a jackpot to a person if the Department of Revenue Registry said that they, were to have a portion of their jackpot intercepted. If I had a team member who knowingly violated that policy, then there would, be a discussion and investigation would happen at the property level. So as I said, it's really more about just making sure that we all understand what our obligations are.
Thank you.
Madam Chair.
Questions? Yes, Commissioner Hill.
So North, this is a process question for the future, because we're all learning about this as we go. So had the sports writer not identified the issue, and this had only been done in the kiosk, would it have been found quick? What would have happened? Like, how would you have found that the mistake if it's done through the kiosk instead of through the sports writer?
So I think ultimately, I would say that the process that I had put in place before was that our managers were to look for wagers that they know that we should not accept on a daily basis. One would hope that over the course of time that somebody would look at that school and pick them out. I think our process at this point is a bit more prescribed in terms of checking all institutions every day. So it could be something that could drag on if it's not caught early. Again, we're super thankful that this team member did notice something and did say something so that we could make a quick correction.
Thank you, Madam Chair.
Questions for Heather, Commissioner Skinner, Commissioner Maynard, Commissioner O'Brien?
I think, Madam Chair, I have a question, but it's more theoretical.
Okay.
I'll direct it to whoever wants to answer it. I don't think this is going to be the case, at least in men's basketball, as I don't think that any team in the Commonwealth is going to make the NCAA tournament this year, but in Massachusetts. But if so, what is the process in place to turn on the wagering and turn off the wagering? Because just to be quite honest, my worry would be that the switch, for a lack of a better word, would be turned on, and then there would be some time where it wasn't turned off properly. So, I'm trying to think about how to mitigate instances where a legal wager can be placed, but there has to be some sort of mechanism in place to turn on and off the ability to do that. And I don't know how much of that is human driven or how much of it is data driven, computer driven.
So an example would be, Commissioner Maynard, the bean pot. Those 4 Massachusetts universities and colleges were eligible to be bet on because it was a tournament of 4 more institutions, Massachusetts institutions. Now, so they got into the system, right?
When do they get
now
out of the system?
Switch them off and switch them on, right?
Who is watching to make sure that they come out of the system?
Yeah.
That's my question. That's a good example, Madam Chair.
And actually, Madam Chair, you've got about 3 or 4 more coming up very quickly, because the basketball, which we call Championship Week, you're going to have a Big East tournament in which there'll be some Massachusetts. You have the ACC tournament coming up. And like you said, Commissioner Maynard, as soon as those are over, they probably won't qualify for the NCAA. You'd have to shut them off immediately. So we actually have a few of those coming up in the next few weeks.
I know that all these are controlled by the IT companies like Canby, GAN, and Barstool. I'm not sure whether they're done manually or via a computer system that does it. I can check on that to get you the information.
Thank you.
So I think you asked a key question though, in terms of how much is automated versus man, and it sounds like to me, Heather, it's a combo, right?
Could well be, Madam Chair.
And I do think that they were focusing on the regular season games, and I will certainly defer to, Bruce and his team on further details on how that actually works.
Yes.
I switched places because there was tree work going on behind me. Dangers of working from home today. Okay, further questions for Bruce or Heather on this? We'll turn to the other item then. Heather, at this point, please, with respect to Encore.
Yes, Chair, thank you. And with respect to the issue that occurred at Encore, it was a little bit different, but somewhat similar. So we have learned that on February 2nd, EBH Senior Vice President and General Counsel Jackie Crum, who you all know, notified Director Band that EBH mistakenly offered wagering on an unauthorized event. So more particularly, this was a Boston College women's basketball game versus Notre Dame. And that was offered for moneyline wagering, which, as I think you all know, is essentially a bet that is based on the outcome of the game only. That game took place on February 2nd at 7 p.m., and that was a regular season game. With respect to kind of the key facts that we've learned, wagering was allowed for approximately 5 hours from about 12:45 p.m. on February 2nd to about 5:35 p.m. on that same day. There was one bet that was placed with respect to this particular incident, and it was actually part of a parlay wager where the BC women's basketball game was one of 5 moneyline selections on the ticket. EBH actually, once they learned of it, they made sure that the VC leg of that parlay was voided prior to settlement of the ticket. And as for the stakes wagered, that was $70 for the full parlay. And then with respect to the winnings, it was about $23 after the BC leg of the parlay was removed. And that particular bet took place at a kiosk. And so with respect to the reported reasons for the error, EBH Director of Sportsbook Operations, Mark Marino, reported that a staff person employed by GAN, which is a vendor to EBH, mistakenly omitted the NCAA women's basketball from the prohibited wagers list. And so although GAN, they place automatic blocks on any mass school team, on a list that was provided to them by WinBet, which obviously also works with EBH as their vendor and affiliate. The blocks are designed to stop any games from a prohibited school from loading into the system, but GAN, however, did not apply that block to the women's college basketball. So upon learning of the issue, I think I might have mentioned this, EBH did freeze the ticket so that it couldn't be redeemed in the form that it was in. And then given that the game hadn't taken place yet, EBH did cancel that VC leg of the parlay. So the remaining legs of the parlay were active. And ultimately the patron did cash that ticket out with the remaining legs. So with respect to remedial and mitigating information, Mr. Marino did report that EBH and WinBet are working to ensure that the prohibited events are blocked from being posted. WinBet will conduct twice daily audits in both the morning and the evening of the mass collegiate sports offerings to confirm that no mass regular season collegiate game, to Commissioner the point that was made earlier by Commissioner Maynard. So with respect to the regular season wagering offerings. In addition, GAN is providing system access to WinBet so that WinBet can review the offerings and sign off on final approval for all the wagering offerings. And further, Attorney Crum has reported that EBH plans to actually assign a dedicated person who who will be responsible for auditing, I should say, excuse me, auditing the wagering offerings to ensure that unauthorized wagers are not offered in the system. And EBH is also coordinating with Director Band's team to ensure that its list of Mass collegiate teams is fully accurate. And I know Sterl has been involved in working with them on that as well. So that's our summary, and happy to answer any questions that anyone has.
Commissioners, questions for Heather? No questions about this? All right, then I think if this might be a good time then for you, Heather, to bring us, actually probably remind us a bit, because we have had some reporting on what other jurisdictions have done in cases like this when we performed our assessment of the applicants for the online sports wagering operating licenses. So you could remind us on what other jurisdictions have done, and then we'll turn to Caitlin, who will update us on the process that we have for these types of matters.
Certainly, Chair. And so, I know we had talked about this on Thursday, and I will say that, we have undertaken a review of the non-compliance matters that have been reported to us previously. And we do have a sampling of those that relate to unauthorized events. One of the things I think I'll highlight is, I think, two things. One is that we can't tell specifically whether the fines that were done by other jurisdictions were after a first offense or second offense. And I think the ones that I will talk about today are the ones that are as closely related to this particular type of unauthorized wagering as possible. So, for example, there are some where there were inappropriate prop bets, but we tried to focus on those that were specifically related to unauthorized collegiate team wagers. And so I would say that the fines in other jurisdictions there was a range. They were kind of around the range of 5,000 going up to 50,000. But again, it's difficult to tell whether, A, the specific facts of each particular incident, and B, whether there was was a first offense or some kind of a subsequent offense. Now, against that backdrop, most of the fines that we have seen that are very close in line with this are in the $5,000 to $10,000 range, and I'll give you some examples. There was a fine out of Iowa where the operator accepted prohibited wagers on 3 different Olympic events. There were 25 wagers placed, 23 that were settled, and that particular fine, just by way of summary, was for $5,000. There was another out of Indiana where an operator offered wagering on an Australian football game, and there was, I think, a settlement in that particular instance, and that was for $5,000. There were, there was another one in Indiana. It was improper wagering on Division II and Division III collegiate events. And there was another component that related to the self-exclusion list in this particular fine. So I just want to note that that particular fine was for $4,000. And again, we don't know if it was for what kind of point in the non-compliance it occurred. In other words, first offense or a subsequent offense. We had another one, I think it was out of Mississippi, for impermissible collegiate football wagers accepted due to an employee error. There was no action on that particular one. There was another one out of New Jersey where wagering was allowed on 2 prohibited NCAA basketball games, and that was a $5,000 fine. There are some others that were higher. There was an unauthorized Olympic events available on 2 kiosks, and that was a $50,000 fine. Now, again, it's not clear whether that was, again, subsequent or first offense or somewhere in between. There were some that, let me just see about the others that were higher here. There was one out of Indiana. It was two counts. There were 11 unapproved MMA events and an unapproved e-sporting event. That was 13,000. And then, let's see here. Let me make sure I get these. There was another one that was wagers accepted on collegiate sports that took place in DC, on a team based in DC, and that was self-reported. There were 2 incidents, and that was a $50,000 fine. So I will say, that's kind of a sampling of what we have gleaned from the information that we've been able to gather up until this point. But generally, they seem to be in the range of, I would say, around 5,000 to 10,000. And happy to kind of, dig a little deeper and supplement if the commission would like. But that's for where we are at this point. That would be our summary of what we found.
Questions for Heather in terms of just those facts right now? Anything that you missed that you want clarification? Oh, okay, that's really helpful. We'll turn to Caitlin now to understand the processes and our options there.
Good morning, commissioners.
Good morning.
So, should the commission decide to issue a civil administrative penalty or contemplate issuing a civil administrative penalty for these issues, there are 3 methods by which the commission could move forward. The first is that it could decide to hold a full adjudicatory hearing in the first instance. This would be allowed pursuant to statute and regulation. And if you chose that option, you would obviously have the full adjudicatory hearing that everyone is familiar with. The operators in question would be part of that hearing. It could be open to the public or closed to the public. And at the end of the presentation of evidence, the commission could decide what kind of penalty it wanted to assess, be that a monetary civil administrative penalty or the condition revocation, suspension of an operator's license. Obviously not that we're necessarily in that territory right now, but those are some of the different outcomes that could result from an adjudicatory hearing. The second option would be to use the notice an opportunity for adjudicatory hearing function that is set out in Chapter 23N, Section 16. So this is a little different. And this is all specifically set out by statute. What would happen here is that the commission would have a discussion in a public meeting like this, about the facts, have a discussion about whether the requirements that are set out in Section 16 of the statute were met to issue a civil administrative penalty. And if those conditions were met, the commission could decide what penalty it wanted to issue, and it would then issue a notice to the operator of the penalty and the opportunity for a full administrative hearing. So that's the second option. I will just to be very clear, the penalty amount is sort of decided before a full adjudicatory hearing in that instance. The third option is to have the IEB conduct an investigation and issue a recommendation. And that is pursuant to 205 CMR 232. So in that instance, the commission would ask the IEB to essentially come back with a recommendation based on its investigation. That recommendation for a penalty would be sent both to the commission and to the operator. The operator would then have the ability to request an adjudicatory hearing, at which point the adjudicatory hearing process would move forward. The operator could also choose to waive the adjudicatory hearing. If the operator chose to waive the adjudicatory hearing, the issue would then come back to the commission for a vote on whether to accept or reject the penalty amount. If it was accepted, you're done. If it was rejected, it would go to an adjudicatory hearing. So the common theme here, a lot of opportunities for an adjudicatory hearing. I would also note that, this is the first time this kind of issue is coming forward to the commission. And so it's perfectly appropriate that we're having this discussion about what method the commission wants to utilize in this instance. It would also be possible for the commission to put together an internal policy on how it wants to deal with these kind of reports in the future. So for instance, what steps are taken when a notification is received? How is investigation status reported to the commission? And how will the commission determine which method to use in assessing potential civil administrative penalties? So that's something the commission could consider moving forward. Happy to take any questions.
Questions for Caitlin. Commissioner Hill?
Caitlin, I pretty much think I know what the answer is, but can you tell us what happens with 23K when there's an instance of penalties that need to be put
With
forth?
23K, and I might have Todd jump in here too, because I've done less of this, but with 23K, I believe there are two options. The commission can have an adjudicatory hearing. There isn't the process of, basically, I think there just isn't the process of notice and then opportunity for hearing in 23K that is allowed in 23N. So the commission could either have an adjudicatory hearing, or the IEB can make a suggestion for or a proposed penalty. And it would move forward in that method. But Todd, please jump in if there's anything I'm missing.
Actually, could we have Director Lilio step in, because I think it's really in her process to explain in Enforcement Council Hall. Not to go by you, General Counsel Grossman, but I know it's going to be straightforward for Loretta to address.
Sure. So Caitlin's exactly right. Under 23K, the commission does have the ability to take a matter in the first instance at an adjudicatory hearing. And the commission has done that in the past in one instance. The other option, which has a couple of sub-options to it, is that the IEB can complete its investigation and can issue the notice of non-compliance to the licensee. If the licensee can decide right then to challenge that and request an adjudicatory hearing before the full commission, at which time the commission would mark it up, have the hearing, and make a determination. The other option is that when the licensee receives the IEB's notice and suggested action, there can be a period of discussion where the licensee can point out mitigating information, additional information, and there can be discussion on an agreed upon fine amount or an agreed upon resolution. And in that instance, if there is an agreed upon action, the licensee waives any right to an adjudicatory hearing, and the action takes hold. Does that answer your question?
Madam Chair, I have one follow-up question.
Could I just ask Loretta, one follow-up to her? So Loretta, is my understanding that when there is a violation, that non-compliance notice that goes out, can that go out? That can't go out automatically. It has to be a first violation for the notice. Can you explain that? And then there's a trigger.
So under 23K, it's clear that before a fine can issue. Now, remember, there are non-compliance matters that the IEB deals with at both the gaming agent level and at the Chief Enforcement Council level that do not necessarily result in a monetary civil administrative penalty. But if you end up with a civil administrative penalty, 23K is stricter about requiring the first violation to have some kind of written notice, and then only subsequent violations can be fined for. In reality, the first notice can come from the Gaming Agents Division, and of course, we have a graduated approach to the adverse action process and the discipline process, because we've been very clear, and the commission has been very clear, that the policy behind the discipline action is to foster compliance and to achieve compliance. And so the way that we have done that is through a graduated approach. And again, that graduated approach can come from sort of more informal writings from the Gaming Agents Division, putting the licensee on notice. In some instances, that first notice does come from the Chief Enforcement Counsel's office. There is a more latitude in 23N to issue a fine for serious violations that go to the heart of integrity without the first written notice. So it's clear to me that in these instances that Heather talked about today, there a monetary fine would be authorized, would be lawful, whereas under 23K, it wouldn't be unless they first got written notice.
Commissioner
Is
Hill,
that
thank you.
helpful?
Thank you. That's really helpful. It's that additional written notice for assessments of a fine. So thank you so much. Commissioner Hill.
Thank you, Loretta. That was very, very helpful, actually. My follow-up question would be, in most cases, it's worked upon between the licensees and your organization before it comes to us, with the exception of that one adjudicatory hearing that you talked about at the beginning of your explanation. Is that an accurate statement?
It is, and I do want to highlight in the gaming realm, given the amount of activity and the years in operation, there have been relatively few fines, and I would expect that, because there is that kind of relationship with our gaming licensees, that we know they are working hard towards compliance, and we take that into consideration. And all of the fines that the IEB has issued have been in agreed upon amounts, and the gaming licensees have waived their right to any hearing in those matters.
Madam Chair, that answers all my questions. Thank you.
Yeah, and Commissioner Hill, I want to remind you of of our recently adopted regulation that Caitlin just went over, that clarified that in all instances the Commission does have the authority to deal with these nimbly and immediately. So, which is a little bit different than 23K. Commissioner O'Brien, Commissioner Skinner, Commissioner Maynard, any questions?
I don't have questions. I have maybe some comments to add to what Loretta said. And Loretta, you can correct me if I'm wrong, but there is a distinction between 23N and 23K, and there's also a distinction between the industries in terms of 23K is regulating a long-standing industry, and the Commonwealth to some extent benefited from years of trial and error and enforcement in other jurisdictions before we launched. So we had a conversation about why we wanted to retain as a commission more flexibility under 23N to act in a way that doesn't exist under 23K, that I do think is necessary for us to have in terms of making sure that this industry that's launching in the Commonwealth knows, what we prioritize, and logistically the realities of IEB's ability to act in every instance if we wanted them to act quickly. You're going to have a number of licensees in 23N as opposed to the 3 in 23K. So I sort of see that distinction on top of what Loretta just described in terms of the difference in the process.
I echo that, Commissioner O'Brien. I do see the two industries as actually, they're gaming, but they are very different, and so much has to do with exactly what was expressed, so much around technology and speed. And so they are different processes, but we have good options that Caitlin outlined. Commissioner Skinner, do you have a follow-up?
I do. I have a process question for Caitlin on those 3 options she laid out for us. Should the commission determine that it would like to see a recommendation from the IEB as to how to move forward relative to the civil administrative penalty, if any, in these matters, how does commission disagreement, or a single commissioner's disagreement, get addressed during that process?
With the penalty, the recommended amount?
Yes.
Okay, so the process would be, at this meeting or at a later time, the commission would decide that it wants to essentially ask the IEB to make that recommendation. The recommendation then goes out. They make the recommendation, it comes out to the commission and the operator at the same time. And if the operator basically either asks for an adjudicatory hearing, to which they're entitled, then it will come to the commission in an adjudicatory hearing, and the recommendation kind of doesn't matter. The commission will make its own decision. If let's say that the operator waives the opportunity for a hearing, the matter comes back before the commission for a discussion on whether to approve the recommendation or to reject the recommendation. So it's at that point that a commissioner who might disagree with the recommendation has the opportunity to talk about it with the commission, whether or not they want to accept the recommendation. And it would be sort of a very standard commission decision-making process at that point. Is that helpful?
It does. Just to clarify though, it's after the operator is notified of the recommendation that that any disagreement gets raised, not before.
That's correct. That's
Okay.
correct. Yes.
Thank you.
Further questions? So today, this is my suggestion on process, commissioners. I don't believe we have to vote, but we can come to a consensus about next steps. I was imagining that we would mark these two non-compliance issues up for a future date for disposition. Today, we can decide whether we want to exercise one of the two options for us to handle it directly, or we could decide we want IEB to go back, do some further work, make a recommendation, then come back to us and still retain this sort of original right to dispensing our decision. Or we could decide to have IEB manage it according to the option that Caitlin outlined. Ultimately, it comes in front of us for either to just approve or somehow amend the IEB's decision. So I am looking for thoughts on preference here. And I may choose in the order that of exercising my own discretion as to who I ask first, because I would like to know, have input from everyone. This is an important first decision-making point on these matters. I think we recognized that we would probably have almost immediately issues with respect to non-compliance given this industry. And that's actually one of the reasons why we worked through that discipline regulation and reviewed the statute. So I'm going to turn to, turning to Commissioner Maynard. What do you think?
Madam Chair, I think that I'm sitting here thinking actually, we're early on in this process of regulating sports wagering. I would say that I want the commission to have as much input as possible at this period and at this juncture, recognizing that potentially we take a different approach in the future, but I just would really like to be able to make some decisions on this and not defer it outside of what I think 23N gave the commission. And so I would elect to be a little more hands-on, especially early on in this process.
I'll do the follow-up as to which of the two. We'll just do generally commission versus IEB now, and then we'll think about the two options as to the commission next. Okay, I'll turn then to Commissioner Skinner.
Thank you, Madam Chair. Like Commissioner Maynard, I do like the idea of gathering as much information as possible before the commission as a body makes a determination relative to any administrative penalty warranted here, if any. Based on what I've heard so far, I don't think that there is a reason to deviate from the way the commission handles these matters under 23K. So I would like the benefit of IEB continuing its work to ascertain a little bit more of the facts relative to the cases in those other jurisdictions where penalties were assessed for similar violations, and make a recommendation to the commission based on their fact finding. I don't want to find facts here, and you know, I don't know if there's a hybrid sort of option where IEB is determining the facts and then the commission is setting forth any penalties that might be involved. But I mean, as I see the options, and I could be wrong, it's all or nothing. So if the commission retains the authority to review this matter in the first instance, IEB is completely out of the process. And
I'm not. Commissioner Skinner, could I actually jump in just for a clarifier on that?
Yeah.
Because I don't believe that the option of our under the regulation of holding an adjudicatory hearing, let's do that one first rather than the public meeting, means that the IEB is out altogether. In fact, I'll have Caitlin and Todd jump in, but my understanding from my experience would be that we would have the IEB report, and it could be its fulsome report if it needs to continue to do some work. It would come to us. We'd be able to ask IEB questions in an adjudicatory hearing. We would also be able to hear the operator and ask questions. We would hear both sides of the story. We would be hearing it and then ultimately making a decision. We could ask, my experience is that IEB could deliver a recommendation in its report, or we could ask IEB to withhold making a recommendation and not give an amount. But it would not be that we would be proceeding without the benefit of IEB. We would be able to proceed with that, but we'd also have the benefit of being able to ask the operators questions directly ourselves. Is that too high of a level of summary, and is it close to accurate, Caitlin?
Yes, if the commission chose an adjudicatory hearing in the first instance, the commission could call in the IEB as one of the parties to present evidence, and the commission could ask the IEB questions much in the course of the normal adjudicatory hearing that you're used to.
And then in turn, the other interested party as well.
Correct, of course, yep.
Okay, and now in terms of the
clarifying question,
yes,
Chair and Caitlin, what information would the commission have available to it in advance of that adjudicatory hearing? I might have missed that part.
If there were an adjudicatory hearing, we would go through the standard adjudicatory hearing process. So we'd have a pre-hearing conference with the operator and the IEB, at which point schedule would be set for submitting evidence for the record for a witness list. You're basically following the adjudicatory hearing rules under 205 CMR 101 and under Chapter 30A there. And so that would all be set. The commissioners would get the exhibits in advance, but you would hear the evidence, take testimony during an adjudicatory hearing.
Okay, and would one of those exhibits be an IEB report?
It absolutely could be.
Could be. Okay, all right.
It's my experience that the IEB's report would always be introduced unless for some reason we said we don't want it. I can't imagine we wouldn't want to hear it. I see Commissioner O'Brien nodding her head as well.
But does that require an affirmative request by the commission? For IEB to be involved, does the commission have to affirmatively invite them to be involved in that process?
I'm going to turn to Commissioner O'Brien. Caitlin, if that's okay, go right ahead, Commissioner O'Brien. This is a really important, understanding this process, these processes are really important. Commissioner O'Brien.
So my experience has been that the commission can direct the IEB to conduct an investigation and define the scope and not ask. They can ask for a recommendation. We can also say, we don't want a recommendation. We want you to go out. These are the factors we want you to investigate. We want you to come back with a report. We're going to do an adjudicatory hearing, and then we're going to decide what the infractions are and what the penalties are, if any. Traditionally, if they've gone on their own and gotten something through 23K and gone forward, it comes to us with a recommendation already in place. So you can ask for it. I think in this circumstance, and to sort of jump the queue, I know we're going in reverse longevity order, so I'm jumping over Commissioner Hill when I say this, but given the new industry, given the fact that this is new, I would like us to be more involved. But I sort of agree somewhat with what Commissioner Skinner was saying, and sort of an open-ended request to IEB to just come forward with something in an adjudicatory setting so that we can make our determination as a body in terms of the tone we want to set going forward.
But
So-
for instance, Commissioner Skinner, in this case, we already have some reports from IEB. We work very closely with our legal team. They would be able to, they would ask us which exhibits we want and, who we want to have as witnesses. And when I said I couldn't imagine that we would not want our IEB, that's our greatest investigative resource to provide us with the facts. Unless we had no IEB, we would still have some investigation done if with a different team. But we're lucky that we have all these resources right here within our organization.
Yeah. So I'll wrap up my thoughts. Notwithstanding that clarification, I still would like to see in these two instances, and I know we have a third one that's headed our way soon, a recommendation from IEB. We've had, three of these now in a week and a half's time. I don't know what the volume is going to be, but certainly as we were reviewing operator applications, we learned that these are relatively routine, and I'm not sure who used the word routine, but they're relatively routine matters. And I don't know if it's an efficient use of the commissioners to review each and every one of these instances, these incidents at an adjudicatory hearing in the first instance.
So I just want to go follow up. I agree. We want to be really, we want to be really aware of resources and efficiencies. The opposite also applies. Our IEB is quite stretched. I also want to point out what Caitlin said, and our regulation encourages this at some point. Once we start to understand the lay of the land, we'll understand what is ordinary and what is expected, and then we could have a policy set up to decide, which items should go to IEB in the first instance. I would say that my inclination is to preserve always the commission's opportunity in any policy would be to always reserve the right for first instance. But you're absolutely right, Commissioner Skinner, to create efficiencies, we'd want to think about that from policy perspective. I also would add that this is an opportunity for us to set the stage somewhat and lead our IEB with our sensibilities as the commission. So I don't downplay that. I also understand that what you're saying, this seems for you to be more, ordinary. Of course, right now, I think that, this is something that I'm pleased to see. All of the two operators have self-reported and taking it very seriously. And they are instituting very significant measures because they recognize it is a violation of statutory law. So I like the response. So from my perspective, we could, you're absolutely right, for administrative purposes, send it to IEB, but there's, we can achieve that policy, and that is something, a bit of homework, Commissioner Skinner, we're going to have to do to get that policy underway. So, but I think that's absolutely the ultimate solution to make sure we don't find ourselves
Yeah.
having to hear, yeah, right. You don't
Yeah.
want to see that either. Yeah.
I don't, and at the same time, I do appreciate your position, Chair, and that of Commissioners Maynard and O'Brien. I would like to, I would, approach it in the reverse, however.
Okay, I just wanted to make
I would get the understanding of sort of the lay of the land from IEB during their identification of these kinds of issues, their reporting to the commission, and then determine whether or not there is an extenuating situation that warrants, an adjudicatory hearing conducted by the commission in the first instance.
And remember, there's an adjudicatory hearing and there's a public meeting option where notice goes out, afterwards. And then for IEB, ultimately it comes before us in any case with always the right to an adjudicatory hearing. So as Caitlin says, adjudicatory hearing, this process, and that's to be clear why adjudicatory hearing is important is because these issues are important for licensure and they reflect upon the operator's interests. So now I'll turn to Commissioner Hill and then
I'm sorry, Chair, one final thought on the public meeting option. I would hardly ever opt for that. I think that, having this information be provided to the operators for the very first time in the public realm, or being able to speak to them anyway in the public realm, is a little unbalanced.
Okay, so thank you. And we'll turn to that issue again, because I know the Commissioner Maynard hasn't been able to speak about that. Commissioner Hill then. And then we'll go back to Commissioner O'Brien for her final thoughts.
Thank you, Madam Chair. Always find these conversations to be very helpful to hear everybody's views on this. So my initial thought when we first started this conversation is, and I hope that we can get back to it at some point in the future, is to have the IAB do their investigation, do their recommendation, and do the work of finding and things of that sort. However, during the conversation, I think I heard the word IEB is stretched right now, and that is an understatement. I think as a commission, we can be helpful to them at this point, at the beginning of this new industry. Get the information, have it come before us. We make the decisions with IEB in an adjudicatory hearing. But I do hope in the future, when we do have a lay of the land and the operators get a sense of where the commission is in regards to these types of violations, that they will understand in the future that when the IEB does their reporting and investigations and come up with a plan for some type of a fine structure, that it is left to them. But at this point, I agree with my fellow commissioners that because of the newness of this industry, that I want to be as involved as I can be with the help of the information that I can get through IEB at an adjudicatory hearing.
Okay.
Plain and simple.
Okay, Commissioner O'Brien.
Chair, I'm sorry, could we turn to Director Lillian, who's unmuted herself?
Oh, I'm sorry. Thank you, Commissioner Skinner. Director Lilios.
Sure, just, great conversation. Interested, of course, obviously, to hear how the commission wants to proceed. And thank you for Commissioner Hill for acknowledging the IEB's workload. But I did want to just reassure the commission that whatever you want to rely on the IEB for, we do have the resources for important matters like this. So I just wanted to clarify on that point that if you chose to go with option 3, we have the capacity to do that.
Thank you.
Can I ask a clarifying question in terms of
you can ask any question, clarifying or otherwise.
In terms of Director Lilios, in terms of IEB in their involvement in either process that the commission decides to take, whether it's hearing the adjudicatory, conducting the adjudicatory hearing or taking a recommendation from IEB instead, is there any difference in the level of commitment and resources that IEB would have to expend? It's the same documentation that's culminating out of your review, correct?
Any discipline matter is a matter of the most importance to the commission and to the IEB. So we are going to dedicate resources to it and make sure that we are thorough and fair, for everybody's benefit. Certainly, an adjudicatory hearing adds a different kind of layer to this, where the IEB is expected to have a role. I totally agree with Commissioner O'Brien that it's expected that the commission would rely upon the IEB for factual review and to present some kind of report and to make available the internal experts on the sports wagering division and in the IEB to be available as witnesses at any adjudicatory hearing. In terms of resources, we are prepared to do whatever needs to be done to resolve these matters fairly and in a way that addresses the commission's concerns and is fair to the licensee.
All set, Commissioner Skinner?
I am, yep.
Okay, I'll turn to Commissioner O'Brien then.
I don't really have much to add aside from what I said already, really, which is that, as Commissioner Hill said, in the long run, when we have decided as a commission, sort of the scope, the scale of fines, that sort of thing, the prioritization of this commission in terms of enforcement, that it would fall for the most part in the first instance to IEB. But I do think at this point, this commission has an obligation to take a more active role in terms of setting what we want to prioritize, what is the range of fines that we want to put out. I know there was some level of discussion early on under 23K with the composition of the commission at that time that gave guidance to IEB in terms of the fines and that sort of thing. I do think it's relevant here. And while I'm always interested in hearing what other jurisdictions have to say, I also feel like we as a body prioritize as we choose to prioritize. And so while it's information I'd like to have, it's not dispositive to me in terms of moving forward and setting the tone on this. So just sort of reiterating what I had said earlier, Madam Chair.
Thank you. Okay, Commissioner Maynard, follow up.
Thank you, Madam Chair. I know you're going to pose a hard question, but if I can just make a point, and it's Commissioner O'Brien usually gets to go first, and it's a hard position, Commissioner O'Brien, I just learned, because I don't think I said everything I wanted to say, which I think you and I are on the same wavelength, Commissioner O'Brien, and I think the work that Loretta and her team does is so important. And I definitely will use it as I've been using it. I read it last night, right? What I believe, and for a lack of a better phrase, is that the commission this early on, and as I said earlier, in its infancy, needs to set the goalposts. And I think you're totally right, Commissioner O'Brien. It's because we may look at it differently than other jurisdictions. We may see things differently. Once we set the goalposts, I totally believe this could go to a 23K type of matter. But we have to start setting parameters. And it was actually something you asked Commissioner Skinner during the questions that really stuck in my head, which was, we will only get to weigh in at the very end if an operator comes to us. The operator may decide it's not worth coming to us, right? It's not worth the additional days off of work to come back into a commission meeting or what have you. And so that really stuck in my head. And so for those reasons, I think I'm following exactly where Commissioner O'Brien, Commissioner Hill, I think Commissioner Skinner are falling, which is I want to set the goalposts with my fellow commissioners early on, and then see how it's working. And I know that's going to create a little bit more work on the front end, both for the commissioners and for the IEB who has to show up and engage in this process. But I think early or later on, it's going to be very beneficial to the entire organization. And so I would say that we have to be a very active participant, Madam Chair. And however, whether it's a meeting option or whether it's the hearing option, I want to be as active as a participant to set the goalposts.
Thank you. And can I ask a clarifying process question then, Caitlin? Just so that I am reminded, if we were to, and I'm hearing that there's a growing consensus perhaps of the commission exercising its discretion, at least in these early stages, but if we were to have IEB at any time do this, the process is IEB works with the operator. They may come up with an agreement, they all, or disagreement, but ultimately there's a decision made by IEB. The
Correct.
operator accepts it, but even if they accept it, they still have to come before us, correct?
Correct. Yes.
And now to Commissioner Skinner's point that, I forget the word that you used, unbalanced. At that time, it will be in a public meeting where the IEB and would be presenting its decision, whether it's agreed upon or not, right?
That's
or
correct.
only if it's an agreement.
If it's agreed upon and the operator waives the opportunity for an adjudicatory hearing, then it would come back to the commission. Presumably the IEB would report on what happened, the fine amount, the waiver, and then the commission would have the opportunity to vote on whether it accepts that amount or chooses not to accept that amount. And then you would move forward with an adjudicatory hearing.
Okay, so at that juncture, Commissioner Skinner, if it turned out that the IEB and the operator were on one end of the scale of assessments, and the commission, whether it's this body or a future body, is really quite divided in terms of how of the choice and the agreement, that would be done in the public meeting. I just wanted to point that out. So where there would be, but it would be at the end, more at the end than at the public meeting option. That is an option for us. But ultimately, the statute did contemplate twice that fines be discussed in public. And Commissioner Skinner, I like that we have options of I understand why you had concerns about that option of a public meeting and addressing fines. We also have at certain points with certain factual situations, there might be an appropriate executive session, but that's more limited, right? Under certain, as we always do. But otherwise, IEB ultimately would always come to us in a public meeting at the end. Just different than 23K. Okay, so we can mark this up. Now, I know at one point adjudicatory hearings were considered this idea that it would be very labor intense and cause delays. I think we've figured out that with our suitability hearings, that they and our other adjudicatory hearings that we've gotten more nimble and we know how to proceed with them. So, but there are some notice matters, Caitlin. So if we were to go with the adjudicatory hearing, what would we have for timelines there?
We would need to give notice, a reasonable notice. So, and of course, we need the commissioner's schedule to be open. So, Todd, within 2 weeks? Does that sound reasonable?
I mean, that would mean that everything worked out perfectly.
Yeah, that would be a perfect.
Probably it could go a couple of months. I mean, depending how things go and how much investigation is going on and all that. So it depends on the situation.
Depends.
Yeah,
on the fact.
apologies. Sorry, that is assuming the investigation is complete and the IAB doesn't need any more time.
Right. And we would be able to have a hearing, and to be clear, IEB has to engage in that process, but then they have to do all the negotiation back and forth. We would be getting it done in a meeting, in a hearing. So we can mark this up for a adjudicatory hearing after notice. Commissioners, we could mark this up in a public meeting and ask for additional information. I'm hearing Commissioner Skinner saying that that's probably really her last favorite option. So where are we in terms of the actual process? Commissioner Hill, you made it very clear, an adjudicatory hearing, and you're staying with that recommendation or that option. Okay, I'm seeing nodding heads. What about in terms of what we need from IEB? We have 2 reports, and I think they're kind of these are factual circumstances. Do we need anything further from IEB at this juncture? Commissioner O'Brien, is there something you would want in addition to what we have?
I don't think so, no.
Okay. Commissioner Skinner?
Chair, I said this earlier, I'd be looking for IEB to provide the information relative to the violations from those other jurisdictions. Heather walked us through a couple of examples, but it would be helpful to have something in writing from IEB that captures some of the some of the similar violations that we're dealing with now.
Thank you.
Can I just note, process-wise, so because now we're talking about a specific adjudicatory hearing, we have to think about evidentiary issues. And so what the commission might consider requesting is sort of a more general memo about fines in this type of instance that could be used in a variety of situations as opposed to a situation specific, because I'm thinking of the rules of evidence. While they don't technically apply to an adjudicatory hearing, you want to be a little bit careful about that kind of information coming in that's not specific to the situation at hand.
Okay.
Is there an issue, Caitlin, with that information coming in at all, or is it okay to have that information come in with just advance notice to the operator? You're muted, Caitlin.
Thank you. Apologies. It would absolutely be given to the operator as part of the adjudicatory hearing, and I'm sure that's fine. I'm just thinking that it's sort of akin to a newspaper article that wouldn't come in at trial. The evidence that would come in an adjudicatory hearing would relate to the specific violation, and it generally wouldn't include information about other situations and fines given in other situations. But the commission could ask for that information separately, just as part of its general business, and just have that separately. It may also be given as an exhibit, but I'm hesitant to sort of have that be a practice where information about fines from other jurisdictions is coming in at an adjudicatory hearing.
Yeah, and I defer to you legal folks, to determine how the information gets to commissioners, but that is something that I would be interested in digging into.
We can work on that for sure.
Okay, so in terms of giving direction to the organization, is it fair for me to say we have a consensus acknowledging Commissioner Skinner's very fair observations about the IEB and how we do rely on them, and also acknowledging the others, recognizing that this may be a good time for the commissioners to just, somewhat set the stage. Am I hearing that there's leaning toward the option that Caitlin outlined at the beginning, the adjudicatory hearing? We would get that underway. It seems to me we could have the two, they're relatively straightforward in terms of facts. How we hear from the operators directly, and we follow up with our questions for them in terms of various matters, and then how we decide to assess any non-compliance will be determined based on the facts before us during that hearing. If does that all make sense, that we're leaning toward the adjudicatory hearing? I just need, I'm going to do a taking the temperature. Commissioner O'Brien?
Yes, that makes sense to me.
Commissioner Hill?
That makes sense to me as well.
Commissioner Skinner, acknowledging your position, how are you feeling about this in terms of anything that I'm missing, noting your first choice was to go straight to IEB?
Yeah, I'm fine with moving forward in the fashion you suggest, Madam Chair.
Okay, and then we'll start to gather a policy, over time. And Commissioner Maynard, how are you feeling?
I'm feeling good. I want to ask one clarifying question, Madam Chair. In this situation, would a recommendation come, maybe this is for Caitlin, from IEB or not, before we started the hearing?
Commissioners, we have an option. Do we want a recommendation, or do we want to allow us to chew on it without that? Commissioner O'Brien?
I think for me, as Caitlin pointed out, the information that we would get in our normal business in terms of ranges of what's out there is informative, but I'm not looking for a specific recommendation from IEB.
Okay. Commissioner Hill?
Same here, Madam Chair.
Okay, Commissioner Maynard, Commissioner Skinner, I know again, your first position, but you should state on the record what you want.
I would love to get a recommendation from IEB.
Okay, and Commissioner Maynard.
With that clarifying question answered, I think I would be more in the realm of Commissioner O'Brien and Commissioner Hill, which is I'm okay with seeing a range. I would say anything that was provided in that vein, I would like to know why it's provided, right? Which would be a little more information. Just naturally what I'm sitting here thinking is, if we were to go forward in a totally different manner and the IEP leveled some fine, I would like to know why they were going to level that fine and how they calculated it. So I think a range is fine, but I do want to reserve the final decision, and I would support the hearing to answer your initial question.
So it sounds like, the question is interesting in terms of you, Commissioner Maynard, asking whether we would get a recommendation from IEB. I think this speaks to your question speaks to the hybrid option that I was referencing earlier. Could the commission ask for a recommendation? I guess how would that recommendation be utilized? Should IEB provide the information, again, deferring back to Caitlin and legal as to how the commission gets that information in terms of, the specifics around the other jurisdictions? In what form would we receive that information? And if we're receiving that information at a minimum, I don't think it would hurt to also get a recommendation from IEB on the amount of the penalty, with the understanding that it would merely be informative and not dispositive.
I do need to just pause for a second. Part of our decision-making will be one, should there be an assessment?
That's right. But if
And
there's
so
a
we want to
recommendation
pause
not
on
to
that.
assess,
So
I'd want to know
so we
that.
would, I'm sorry?
I was saying that if IEB is, if there's a recommendation from IEB not to assess a penalty, I would find that information valuable. Again, not deeming that information or that recommendation as final, but it would be good to know.
So I want to point out, so there's whether or not there would be a finding of that there should be an assessment, and then what it is. Having been the beneficiary of a hearing, was enormously complex. So one might have thought it would have been a necessity to have IEB give a recommendation. Having no recommendation allowed the commissioners to have very fulsome discussion and to come to their own conclusion and to own it. I would say that I inherited that. When I came to this commission, I inherited that decision that there would be no recommendation. So in my mind, I'm very comfortable with that. I'm also very comfortable with the idea that at some point these matters of certain qualities would go to the IEB. I see that that's the distinction. If we're going to own it, I'd like to be able to ask both parties, both sets of witnesses, IEB and the operator, fulsome questions and be able to make a decision on the facts before me. If there's a recommendation coming, I just want to point out that might be more limiting for our discussion than we might be anticipating right now. Commissioner O'Brien, you had the benefit of that as well, but you've seen more probably than I have with your extra year plus service. So I don't know how you feel when you think about that.
No, so part of the reason I'm not looking for a recommendation in this instance from IEB is in no small measure the hearing that you're talking about. And I also inherited the decision when I came in, that decision to request IEB to do the investigation without a referral recommendation preceded my appearance on the commission. But right. I agree with you. My concern, and part of the reason I even want to go through the adjudicatory process and something like this now, is for the five of us to set the tone and the parameters and the range. My hesitation with asking IEB to come up with that right now is that an expectation is then set that we're then working against, as opposed to we get information about what's in the ether in other jurisdictions, and then we as a five come together and make the decision. So I actually don't like the idea of IEB giving us a recommendation at this point for that reason. I do go back, and there was a range of opinions back in 2019 when we did that hearing in terms of fines in particular in total amounts. So I don't really want to have the process influenced by the recommendation from IEB. And this is in no way to disrespect IEB or their expertise, but we are also in a new industry. And so that's part of the reason where I would like this commission to take somewhat of a lead in terms of what we think. And then once that's established, and IEB knows where this commission sits, and that may fluctuate over the years. But I think going forward, particularly as we launch, that's what I would like to see.
I gave that background, Commissioner Skinner, because again, I inherited it and I wasn't the beneficiary, I guess Commissioner O'Brien, you weren't either, of why that decision was made. But it did allow for us to start with a complete clean slate and come to a consensus among the five commissioners. And the makeup of each commission will always be different. And so for the launching of this industry now, as Commissioner O'Brien's pointed out, it kind of sets that tone. A policy may also down the line will further set that tone. And my sense is as the commission evolves, there will be changes as we see the industry and see how it operates. But I think this is kind of our leadership role, is how I feel. And this happens to be the first matters that are before us, right? These are the first ones that have come to us. And
Chair, there's some legal reasons for that as well that, if I may be heard, it may be helpful as you continue to process this. But in the other areas that IEB does give recommendations, that is based in statute or in regulation. You know, when we give a recommendation on a qualifier, the statute says that. On a gaming licensee, the statute calls for that. When we do assess a fine in the gaming realm, we give the notice of the intent to assess the fine, but part of that process is that we invite the licensee to present mitigating information. And that process, the process is then protected from on a further review by the mere fact that we have invited that further information at that stage. It would be, I think, if you do go to an adjudicatory hearing, which is, you know, what I'm understanding, not only is there not a call for an IEB recommendation in the statute or the current regulations, but certainly to get any kind of recommendation before you've had the hearing would not be something that the IEB would even be able to do, because, you know, the whole purpose of having the hearing is to hear both sides of the evidence, and the IEB would not have performed that function in this scenario that you're talking about, going to the hearing in the first instance. So I think the IEB is very limited in its ability to provide a recommendation, you know, going into a hearing.
well, I suppose, well, maybe not, Caitlin. We just try to think about Commissioner Skinner's interest. At the conclusion of the adjudicatory hearing, all the evidence is now before us. Could the commission then ask the IEB for a recommendation if it wanted it? After everything's been heard? I'm trying to think of the most complex matter where all of a sudden we are struck like we would like that recommendation.
As Director Lilios noted, that is not directly in the statute or the regulation, but I suppose if the commission had heard all the evidence, decided it did want to issue a penalty, and then it wanted further input from the IEB on the amount of the penalty, perhaps it could ask for that after the fact, after everything else is done. I would like to sort of look into that a little bit more, but it's potentially a possibility.
Okay, thank you.
Like a sentencing recommendation kind of thing.
That, you know, and you know, I don't have that background, but I was thinking of my colleagues who do have that background. So, all right. So commissioners, can we turn to just now directing legal to work with the parties, IEB and the operators, and I think to line up 2 dates in the near future, not 2 months out, closer to 2 weeks. And I know Todd is thinking what, but you know, in the realm of reasonableness in terms of our schedules to get these matters underway in a nimble fashion. Our fellow regulators across the country have been able to act promptly on these matters, and I'd like to be able to replicate that. You know, understand that we have our own statutory requirements. Is that enough direction for now, commissioners? Is there anything further that we need to give? Karen, what do you think? Is there anything that we're missing? And Caitlin and Todd.
We're all set.
Okay, Caitlin and Todd, all set.
I think we're all set.
And Trudy, of course, is our takes care of all the commissioners' schedules. So please be in touch with Trudy about our schedules. And there she is. Good morning still, Trudy. Thank you so much.
Morning.
All right. Anything else? All right. Really important discussion, and it had to go long because it's our first day, our first time at this, and so it's really helpful to get through the process a bit. Before we now go to item number 4, Commissioner Skinner did reference that there has been a third non-compliance issue that's come to the Gaming Commission's attention. I don't want that to garner attention and somehow suggest that we're not not being transparent. We just had an update from you, Director Band. So I wonder if you want to give us an update on that, and that will be something that we'll be looking at.
Yes,
in the future.
We've been notified by the third licensee, MGM, that there was an incident of betting on a Massachusetts basketball game, which happened to be Harvard. It was the Harvard-Yale game, the Harvard-Brown game. We were notified this weekend of that, and it's currently being investigated.
Okay. And that was
Chair,
also...
Sorry, Chair, I would just add that Attorney Kramer is going to be working with Director Band on preparing a similar summary that we provided with respect to the 2 matters we were discussing today. I expect that will be, relatively soon, and certainly open to hearing the Commission's feedback on when they would like to have that summary. Just wanted to let you know that we're basically approaching it in the same way as we've approached the other 2.
Okay, excellent. And just as a reminder, it was self-reported?
Yes.
Okay, thank you. Any questions, commissioners, on that? All right, well, we'll get the update on that as we have here and proceed. All right, Karen, Executive Director Wells, we're moving on to item number 4. Commissioners, it's 11:45. I'm thinking that these matters might be relatively straightforward, but we never know. So I'd like to continue on unless we need a 5-minute break, commissioners. Okay, let's continue, but wave your hand if you need that, okay? Here we go.
Okay, so I'll start with item 4A, the determination of Massachusetts boundaries. This is well marked up for a vote. That was a cautionary measure. There is no vote that needs to be taken today on this matter. It's more of an update for you as the Commission. As you're aware, it's defined in 205 CMR 243.01. All bets are to be placed in the Commonwealth. I believe that's also pursuant to the Wire Act as well. So the geolocation vendors and our operators had requested the definition of the Massachusetts boundaries. As such, our legal team has worked both internally and with our outside counsel and an expert on tribal law to gather information on this issue. Generally, the state border defines the area where people can bet on their phones or mobile apps. But there are 2 notable issues I just wanted to make the Commission aware. The border for geolocation purposes does extend 3 miles into the water off the Massachusetts shore. So outside counsel Milan Povich had researched that for us. And yes, people in their boats can bet on their phones if they're in the water. So we did get some confirmation of that for legal purposes. And secondly, we have identified the sovereign tribal land of the Mashpee and the Aquinnah needs to be geo-fenced off for purposes of sports wagering and mobile sports wagering. And out of respect for the tribes, the chair has reached out to both of them so that the lines of communication are open on this process, and we honor the sovereignty of the tribe in this respect. We are ready to go. We'll be in contact of some last minute details on information to the geolocation provider, but I expect we'll be ready to go, and no vote, as I said, is needed today. If there are any issues, we'll come back before the Commission or notify if there were any concerns, but we expect that this part of the process in launching sports wagering should be all set to go going forward. Are there any questions on that?
Karen, no questions. Actually, there's a question, but it's just on process. you indicated that Attorney Povich was advising on this matter. Is there any material you can share with commissioners relative to his legal opinion?
Todd, I don't know if he did anything with risk because he looked into the water area, and then we have another tribal expert dealing with the sovereignty of the tribe, and we also had some internal research. I don't know, Todd, if you can answer that question.
Yeah, there's a Supreme Court case that talks about the boundary of the Commonwealth of Massachusetts, the United States versus Maine. It was a 1975 matter, and we can get into a little bit of the details if that would be helpful. But that it basically says, and Caitlin can refine what I'm about to say here a little bit, that the boundary is a geographic boundary that stretches 3 miles into the water as opposed to a nautical mile. By way of contrast. So that's where that 3 mile figure comes from.
Could you share that case, Todd, and any other legal research that you guys have conducted? Just looking to stay informed on the issues. Thank
Absolutely.
you. And so that concludes item 4A. For item 4B, I'm going to turn that over to Bruce and to Sterl. Where is Bruce?
Bruce is.
Did we lose Bruce? I can check.
No, we've got Sterl, but he'll come right back. I'm sure. Maybe he's going to heat up his coffee like I'm about to.
I'll go check next door. He is right next door to me here. Hold on.
I'm sure he'll be right back.
Okay.
Madam Chair,
Yes,
this might be a good time for a 10-minute break.
I think so too. Let's go back and return at noon. This way everybody can take a break, and I think we'll be able to wrap up before lunch. Bruce is back, but we'll take a 10-minute break. Thank you so much.
Thank you.
All set, Dave?
I'm back now.
Oh, there you are, Bruce.
Yeah,
Oh,
my phone rang and I was on the phone.
I had the opportunity to grab my cup of coffee. So there we go.
Good. It's a win-win then.
It was more than that. Thank you so much. All right. As we've just thinking, we're just waiting. Commissioner Hill, you're on. Just wait for him to come back. Here we are. We're reconvening public meeting number 435 of Massachusetts Game Commission because we're holding this virtually. I'll conduct a roll call. Commissioner O'Brien,
I am here.
Commissioner Hill,
I'm here.
great, Commissioner Skinner,
I'm here.
and Commissioner Maynard.
Here.
Great, thank you. So we were just about to turn to item 4B on our agenda. And I turn now, I think, Karen, I'll let you do the introduction.
You're muted, Karen.
Turn that over to Director Band and our manager, Bruce, Stuart Carpenter, to deal with this issue.
Yep. And I'm here now. So
Okay, that's good.
Yeah, right. The Sports Wagering Division has received questions regarding whether certain types of wagers may be offered pursuant to 23N regulation and approved sport wagering catalog. Specifically, questions have been received related to the offerings for awards given to individual collegiate athletes, future bets on Massachusetts collegiate teams that have not yet qualified for a tournament, wagers on Massachusetts collegiate teams if the outcome of the event is decided via regular season results only, and associated issues related to the scope of permissible wages. We have in your packet a draft fact document sets out questions that have been received along with proposed answers by the Commission's review and input. Once approved, the fact can be posted by the MGC on the website and distributed to operators. While answers are pending, the operators have created offering sports wagers awards given to individual collegiate athletes, future bets, and Massachusetts collegiate teams have not yet qualified for a tournament, and wagers on Massachusetts collegiate teams, excuse me, while answers are pending, the operators have ceased offering wagers on awards given to individual collegiate athletes, future bets on Massachusetts collegiate teams that have not yet qualified for a tournament, and wagers on Massachusetts collegiate teams if the outcome is decided via regular season results only. Any bets already placed on those teams' offerings have been locked to the extent that they exist. All right, and I will have Sterl go over the wagers with you. Mr. Carpenter.
Thank you, Mr. Ban. So Caitlin and Todd went over questions that the Sports Wagering Division received. We received questions on the Heisman, on wagers that partake in tournaments, and wagers of regular season. Attorney Monahan put together a frequently asked questions from with the statutes and the legal division's interpretation. And I'll turn it over to Caitlin since she provided the memo to the commissioners. Thank you.
Thanks, Joel. Appreciate it. So commissioners, what I would propose is to do is just walk through each of these questions, and we can pause after each one in the event there are any questions. But just wanted to get your input and thoughts on this before, of course, anything went live, because it does relate to what types of sports and wagers can be offered in the by the sports wagering operators. So the first question, pretty straightforward. Can a sports wagering operator offer a wager on a college team from Massachusetts that is not involved in a tournament? Pretty straightforward no on this. The statute is very clear that operators aren't permitted to offer wagers on college teams from Massachusetts that aren't involved in a collegiate tournament. Let me know if you have any questions on that, but I think that one is pretty straightforward.
Can I just get a clarification, Caitlin? You said aren't or are not, correct?
Are not involved in a tournament. Yep.
Thank you.
So the second question is, can a sports wagering operator offer a wager on a college team from Massachusetts if the outcome of the wager is decided via regular season results only? And just to clarify what this means, can an operator offer a wager on a Massachusetts team winning the Big East, which is not a tournament, it's just the team with the best record in the Big East Conference? And the answer to that we believe is no. For the reasons explained above, you cannot offer a wager on a Massachusetts college team if the wager is not decided, if the outcome of the wager is decided via the regular season results only and not via a collegiate tournament. The exception is actually pretty small for wagers on Massachusetts collegiate teams. They have to be involved in a collegiate tournament, which is defined as a tournament with 4 or more teams. All right. The next question is, can a sports wagering operator offer a wager on a college team that is not from Massachusetts if the outcome of the wager is decided via regular season results only? So same situation as the last one, except the operator is offering a wager on a team from outside of Massachusetts, basically winning the Big East, winning a whole conference. The answer to that is yes. The prohibition on collegiate sports only applies to Massachusetts teams. So the operators can offer wagers on college teams that aren't located in Massachusetts, and that is not a problem. Here's one that is a little interesting. Can a sports wagering operator offer a wager on a college team from Massachusetts for an event that will be decided as part of a tournament where the Massachusetts team has not yet qualified for the tournament? So the example here would be, can you offer a wager on a Massachusetts team for a game that will occur as part of the March Madness tournament before the team has qualified for that tournament? And our proposed answer to that is no. And the reason for that is that the statute talks about or defines the term sports event or sporting event as a professional sport or athletic event, collegiate sport or athletic event, collegiate tournament, motor race event, electronic sports event, or other event authorized by the commission under this chapter, provided, however, that it does not include a collegiate sport or athletic event involving 1 or more collegiate teams from the Commonwealth unless they are involved in a collegiate tournament. So what we're looking at there is the are involved in. They have to be presently involved in, not hypothetically involved in the future. So we believe that until the Massachusetts team actually qualifies for the tournament, bets cannot be placed on that team. So I'll pause there for any questions. Okay.
Oh, yeah, all set, commissioners, so far?
Thank you. I will also note that we talked about situations where Massachusetts teams are automatically qualified to participate in a tournament, an example being the Bean Pot, where it's the same 4 teams every year. And we do believe that in that instance where you always know what the teams are, they are already in the tournament, you could do what's called a future wager on those teams.
Madam Chair, now I do have a question.
Okay. Okay, that's Commissioner Hill. Thank you. Yes.
So with that scenario, I know that BC is going to be I think they're part of the ACC, correct me if I'm wrong.
Correct.
You know they're going to be part of the ACC tournament because everybody qualifies for that tournament.
Yeah.
So what's the difference between the Bean Pot and the ACC?
There wouldn't be. If it's a tournament where everyone applies, like the ACC tournament that you're just talking about, you can do a future wager on that because they are involved in. You know that they are going to be in that tournament. It's just a situation like March Madness where not every team qualifies, that you have to wait for the actual qualifying event.
And that would be the same with the NIT as well.
Now you're getting too complicated for me, Commissioner. But I'll let Sterling.
Another tournament.
Yes, another tournament. So we're outlining this, Commissioner Hill, because basketball currently has everyone qualify. So there were several years back that they didn't, right? So at that point, they would be excluded. Football, no one makes that Final Four until the very end. So football would not have these wagers as basketball does. So yes, you are correct.
Okay, thank you.
I have a clarifying question that Commissioner Hill just sparked in my mind. Caitlin, so what you're saying, I just want to make sure I'm understanding this. Let's say today, it's pre-selection Sunday today. If I went and wanted to do a future on UMass Amherst to win the national championship, I couldn't do that.
Correct.
Right. But let's say it's selection Sunday. I don't think it's going to happen this year, but let's say
I guess
it happens next year. Right. And UMass then is announced that they qualify. I can go that day and make the future bet. Correct.
Correct.
As long as the operator corrects their inputting, right? So I'm assuming the platform provider will then need to allow that wagering to take place.
And that's actually goes to my question earlier,
Yeah.
Sterling. But
Yes.
yeah, that's why I asked
That's
that.
what I was going to say. It goes to your question earlier of when the flip is switched. Once they are qualified, then it's up to the operator to flip the switch and allow the wagering on that.
All right. Thank you.
Great. All right.
Commissioner Hill?
Yes. So to Commissioner Maynard's question, and just for clarification, because I get calls from friends and family and all that good stuff. So as soon as that selection is made on Selection Sunday, if the operator flicks that switch that minute, I can go bet on that game.
Yes.
Yes.
Interesting. Okay, thank you.
Okay. Great.
And we're not ruling out anything for this year.
All right. Excuse me. Okay, the next question is wagering permitted in a collegiate tournament that occurs in Massachusetts? This is a question you received, and the answer is yes. You may offer wagers on collegiate tournaments that occur in Massachusetts. There's not any statutory or regulatory prohibition on offering wagers based on the location of the tournament. It's based on the location of the team in the tournament. So teams from Massachusetts. It doesn't matter if the tournament is in Massachusetts or not. Next question is, are sports wagering operators permitted to offer wagers on awards given to individual collegiate athletes, such as the Heisman Trophy or the Wooden Award? So our proposed answer to this is no. Operators are not permitted to offer wagers given to individual collegiate athletes, and that's based on a reading of 23N and the statute. I will say this one is a little bit, is perhaps a little bit more open for discussion, but there is a prohibition in the statute on, and I'll read it right here, it's section 3 of 23N that says sports wagering shall not include the acceptance of any wager with an outcome dependent on the performance of an individual athlete in a collegiate sport or athletic event, including but not limited to in-game or in-play wagers. So, our interpretation of that, or my interpretation of that, I should say, is that the Heisman Award would have an outcome dependent on the performance of an individual athlete in a collegiate sport, in football, even though it's not based on a specific event or a specific game. There are, potentially different ways in which that could be read, but I think that is what I would recommend. But happy to take questions on that.
Can I just ask a question in terms of timing? These could be, these kinds of bets can be placed very early in the season, at any time as a future bet as well, right?
Correct.
So that's where the element of performance comes into play more.
So with the Heisman and the Woodard, yes, we can say that it's based on their statistics on the game, on the football field or the basketball court, but it is not. It's many different positions in football. Everything is considered And there are a multitude of factors besides just who throws the most touchdowns or most yards or scores the most touchdowns. So it's not just if somebody does X, they're going to get it, right? And it is also an award, which you also voted on, that you are allowed to place wagers on awards. So it skates the sides of both sports and awards. So this is why it was contemplated. That's why we really wanted to bring this in front of the commission to get guidance on what you feel as well.
So let's put it into perspective. If this were Doug Flutie's year,
Exactly.
right?
Yep.
And let's say it's October or November and not, what month are we in, Sterl? February.
February.
With my red. The bet would be who's likely to win the Heisman, but the wager would be placed, if they were backing Doug Flutie, would be placed on a Massachusetts athlete.
Well, it's not just a Massachusetts athlete. It's all, the statute is any individual.
No, I'm saying, but in that case, it would be a Massachusetts athlete. But
Yep.
in terms of how the bet would, how the bet would go, just the bet, not the law, Sterl. How would the bet would say, who do you think?
Yeah, they would say, they offer in the words it's offered, who will win the Heisman Trophy? And then they have a selection, and you can go down every single college name on a list, and they have an appropriate odds set next to them on winning it.
And if it were Doug Flutie's year, Doug Flutie's name would be included, and the question here would be, could it be included in Massachusetts?
I don't think it's really the in-state issue.
It's
That's
not
really
an
what we're talking about.
It's overall, because the statute says cannot be based on an athlete's individual statistics. So the reading there by the legal department is they're saying, no, the award is won by his statistics. Now, it's not an individual game, it's an entire season long statistics that he or she goes to winning this award. So there's just a multitude of angles, but as Caitlin is saying, they see it as it's their statistics, and that's not allowed via statute.
And perhaps I thank you, that's Sterl. It's very, very helpful. And I think just to clarify, I am focused on the language there that says, you cannot, sports wagering doesn't include the acceptance of a wager with an outcome dependent on the performance of an individual athlete. So it's an award for an individual athlete in any collegiate sport. And I think, football, again, we're just talking about the Heisman as an example, but a collegiate sport would be football. So I think that's where I believe the prohibition comes in on this.
And I agree with that, Caitlin, in my reading. That's an individual act. It clearly states that you can't do that. Sorry, Matt.
No, I'm sorry. I was just going to say I'm going to tread carefully here, because I don't know if I want to be opposite Commissioner Hill on this. And I'm not saying that I don't agree with the legal advice, but I was glad to hear you say, Caitlin, that this one is a little more open for discussion, because it's the only one of the scenarios that gave me pause. And it seems as though your legal is fitting the awards ceremony. I don't, and I'm almost embarrassed to say I'm not familiar with. I'm familiar certainly with the Heisman Trophy, but I'm not familiar with the Woodard. And I have now an entirely new lens with which to start looking at these college sports and events. But it sounds like you're fitting these awards within the definition of collegiate sport or athletic event. Is that right?
Well, collegiate sport or athletic event is certainly a defined term. I'm not saying the award is within it, but what I'm saying is the award is the awarding of the trophy, right, is an outcome dependent on the performance of an individual athlete. An individual athlete has to be chosen for the award based on their performance in a sport. And so that's where I'm saying it connects. I don't think it actually matters that it's an award versus, a wager that Doug Flutie's going to throw a touchdown on the next play. I think it's the same thing. It's an award based on an individual athlete's specific performance.
Okay.
And let's be clear, an individual of a college game.
Yes, collegiate, yes.
A college game. Can I just back up? I got corrected about whether it was in Massachusetts or not, and I'm not really sure what you were driving at because I think I had it right. But Todd, could you explain to me why you were correcting me? Because I thought I had it right, but I guess not.
Yeah, we're talking about two separate areas of the statute. The in-state stuff is the carve out from the definition of a authorized sporting event, which talks about a collegiate sport or athletic event involving one or more collegiate teams.
So this would be all Heisman. It wouldn't be just Massachusetts.
Yeah, this is every college player. And it's a different section of so this is really in the definition of sports wagering as opposed to sports event.
Thanks for the
there's
clarifying.
that carve out. And just to put a finer point on what Caitlin is saying, so and the reason why, to Commissioner Skinner's question, it's an open question. The question is whether the Heisman Trophy, the Wooden Award, the Hobie Baker Award, all these end of season awards are really dependent on the performance of an individual athlete in a college sport or athletic event. Do you consider the regular season to be a college sport or athletic event? Or is it just a kind of holistic view of the athlete's performance over the course of a season? And that's really why there's some discretion here as to, so you can't bet on an individual athlete's performance in a specific game. I think everyone would agree on that. You can't say Bryce Young is going to throw 4 touchdowns, in this particular game. That is impermissible under the statute. But can you wager on whether he'll win the Heisman Trophy at the end of the year based upon an assessment of his performance over the course of the whole year? It's a slightly different issue. And that's why we brought it here before you, because it's not black and white.
So commissioners, even if it's not black and white, we have the discretion as to what can be in the catalog, right? Is that right, Todd? So if we are we obviously, if we're leaning more conservatively to exclude it altogether, we could do that in our catalog, even if there's some gray area in this interpretation.
Yes, I think that's right. And Caitlin, she and I were just talking about kind of making sure that there are no unintended consequences of some of these decisions, and that's important to keep in mind too. But I don't, Caitlin, correct me if I'm wrong. I'm not sure if there was one that kind of came from this.
Yeah, so the issue here, and again, statute could potentially be a little bit more clear, but to the extent you're grappling with how to define sport or athletic event and whether you consider that to only include events or also the sport as a whole, like the sport is the football and a football game or just football games, if that makes sense. This could have an impact on the prohibition on wagering on high school and youth, because high school and youth use the same language in the statute. So to the extent the commission decided that the term sport or athletic event only includes events, you'd find yourself with potentially an unintended donut hole in the statute that could be, someone could argue that you're supposed to be you could vote, wager on youth or high school events. And I think we're all pretty clear that that is prohibited by the statute.
That's right. That's right. Commissioner O'Brien.
So, yeah, I'm glad that you pointed that out because I hadn't even gone that far. My hesitancy with expanding the catalog, I think you got to torture the language a little bit to get to that concept that, well, I'm just looking holistically, not individually, so therefore it's okay. Because my understanding too of the intent was to protect the student athletes, the collegiate athletes from any sort of pressure or repercussions. And to me, while it might not be a particular game, I think we're subverting the intent of that ban if we
Commissioner-
interpret the statute around it.
Commissioner O'Brien, my thought was exactly yours. And so I was thinking if there was a notion that there's somehow allowing for the Heisman voting, given the intent, what I see as the general intent to protect the collegiate athlete, I would say, well, if the leaning of the statute is one way, we still have discretion to rule it out. That's really my thinking, but others may disagree. But I agree entirely with you, and you have been a great voice for the college athlete. Commissioner Skinner, are you unmuted?
I am. That's what ties it up nicely for me. I agree with the two of you. I did just more. I mean, I have to say I was grappling, just for the reasons that Todd described. But I also took a look this morning at the advertising regs, which prohibit endorsement of college athletes. And so, I think to be consistent with what our objective is there, I think the proposed answer to the question is correct.
Okay, Commissioner Maynard, how are you feeling?
I'm the fly in the ointment, which I am perfectly comfortable being. I look at more or less how the selection process goes. For example, the Heisman, has 6 sections. There's approximately 870 voters that are voting from different media outlets, and then you have a number of former Heisman who can weigh in on the matter. And so I would look at it more of, if I'm going to make a wager, I'm looking at how the selection process works, how it's going. There could be external factors, as I think Todd mentioned. I'm a little biased on the Wooden Award, seeing as Oscar Sheboy from the University of Kentucky is the current awardee. But again, it's the same situation where you have 1,000 voters, right? And so I was pretty dogged wanting to allow MVPs and so forth to be voted on. I understand that this is truly a tough one because it does include individual college athletes, and I am sympathetic to that, but at the same time, it's harder for me to see the harm in someone selecting a favorite player and putting some money on it, given that the way it's selected is so broad. You're talking almost 1,000 people on each one that make a decision. So I think that I may be a lone dissenter here on this one, but that's okay.
That is okay. I will like a follow-up, but I'll turn to Commissioner Hill first.
I agree with Commissioner O'Brien and Commissioner Skinner. We need to remain consistent here in regards to our collegiate athletes. So at this point, I would agree also with what legal has put before us.
Thank you. And my only follow-up, Commissioner Maynard, is that we did agree with respect to awards like the MVP for the NFL, but those are, again, the adult athletes, professional athletes. And because I think these bets can be placed at any time, I think from my perspective, the intent of this Massachusetts legislation was to alleviate that pressure on athletes. I know it's a fun bet. So for the bettors in Massachusetts, they may not be able to place that bet, but it is the pressure on the athletes very early on that might become quite aware that their performance makes a difference ultimately with respect to sports wagering. And I think that I'm really comfortable giving, as Commissioner Hill said, to be consistent. So,
Madam Chair,
yes.
I might also add that we can revisit this at any time. And we should, once we get up and running in 6 months to a year. Some of these things that we have chosen not to adopt at this time, we may have a change of mind in the future. But for today's purposes, I think what has been presented, we should be adopting.
Can I add
Commissioner Maynard? Yes.
just one other thing is to Caitlin's point about opening this up to high school. I want to be clear and on the record, because the selection process, so forth, I would never read this to extend to that. I see that the reading could be made. I don't think that me or any other commissioner on this body would read that way.
Oh, I'm sorry. Read which way?
We would never read to include high school sports. I mean, in the
On
parade
the
of
high
horrible,
school. Yeah.
yeah, the parade
Yeah.
of horribles she offered, that was one of the unintended consequences. I don't think
No,
get there.
that's, yeah, thank you for that clarifier. And I'm sorry, I missed it at the very beginning. So the one thing I wanted to follow up then, Commissioner Hill saying we could revisit, is this decision to include it as an FAQ sufficient, or do we need to clarify in the catalog?
I mean, in the first instance, I think the FAQ would be very helpful, and we can send it around to the operator so they're clear. Especially, I don't think we need a vote necessarily, but once there's clear approval of the commission, if you choose to amend the catalog, we could absolutely do that just for total clarity in the future.
Yeah, that's what I'm looking for guidance. Director Band, do you want that, or?
For this is clarity, you mean? I'm sorry, I
To
didn't.
include it to, if we were to decide, you know what, for right now,
I think for right now, I agree with what Caitlin's interpretation is on this. I wouldn't include it at this
not
point.
in the catalog.
Yes.
Okay.
Okay. There's one last FAQ if we're
Oh,
done
there
with
is
that
one.
piece. There's, yeah, the last one. And this is actually not catalog related, but it's a question that we've gotten multiple times. So we want to make sure that's out there and clear. And so the question is, I currently work for a sports wagering operator. May I wager on sports through any of my employer's platforms, mobile application, window, kiosk, etc.? And the answer to that is no, and that is per regulation. So employees, subcontractors, directors, owners, officers, or qualifiers of an operator, as well as those within the same household, shall not place wagers through the operator or through any other operator tethered to the operator on any event. And so that means that if you work for a Category 1 operator, you work at Encore, you can't place a bet at Encore at a kiosk, and you can't place a bet through the tethered Category 3 operators that are tethered to Encore's Cat 1 license. And so we just wanted to be very clear about that, put that out there so that everyone knows what the deal is on that.
Madam Chair, I have a question.
Yes, and I need a clarifier. Yes, Commissioner Hill.
Caitlin, does that mean that employee could go to MGM or PPC?
Yes, they could. Yes.
Right, and I realized I was confusing the issue by suggesting it's not a you don't put a negative in the catalog. So I'm thinking to myself, so nobody pointed that out to me, but you wouldn't you can't vote on Heisman in the catalog. So just our FAQ will suffice. So thank you. I'm thinking this process through, Director Band.
Yes.
It's also almost like a house rule, I was thinking, rather than the catalog of allowable events. So thank you. And in terms of this FAQ list, should we assume that this is going to continue to grow because it is probably dynamic, right, Caitlin?
I think so, and I can defer to Bruce and Stroll on that, but we have seen a lot of questions coming in, and what we've done with these questions, you could probably tell we didn't get that exact wording. We took a bunch of questions, we boiled it down to these, and we'd like to put these on the website for clarity so that we don't have to answer individual questions one-off, and also just for consistency. But we can continue to sort of bring questions back to the commission as they come in.
That's excellent. And if you could work with Mills too, because I'm sure you have been, but he Tom Mill gets questions, and I know wherever we can add clarity, it will help everybody through these FAQs. Okay, this is excellent. Very, very, very helpful, and I see the nuances developing, Sterl. Thank you very much.
Thank you.
Okay, anything further on this? Commissioner Hill, you've got basketball to concentrate on now that football's done. But what about hockey?
Well, as you probably know, the Hill family is a hockey family, and has been since the birth of both of my children. So we have figure skating as well as hockey. So we're watching all of it unfold, including basketball.
Yeah. Well, I know Executive Director Wells has got some hockey players in her household, so.
I know
There we
Commissioner Maynard can appreciate this, but there's been a lot of upsets in the college ranks this past week and 2 weeks. So it's going to be a very interesting NCAAs for sure.
All right. So we're now turning to, I guess, if there are no other questions or comments, turning to our executive, a request or consideration for an executive session. Commissioners, I'll let Todd set the stage and we can decide whether or not we want to move into an executive session.
Certainly. Thank you, Madam Chair. The Commission was recently notified by way of written correspondence from the Department of Labor Relations that the gaming agents division has sought to organize with a union known as SEIU Local 888. And in preparation and strategic preparation for collective bargaining discussions with that organization, it would likely be beneficial for the Commission to be briefed as to the status of the situation and to have presented before it a couple of decision points as far as moving forward is concerned. And we do have outside counsel working with us on that. And so the executive session provisions of Chapter 30A, the Administrative Procedures Act, allow for a public body such as the Commission to go into executive session to discuss this exact subject matter. And if you are so inclined, we are prepared to brief you and lay out some of the questions before you.
Okay, Commissioners, as we consider this, you know that I need to read this language into the record. The Commission anticipates that it will meet in executive session in accordance with GL Chapter 30A, Section 21A3 to discuss strategy with respect to collective bargaining in light of the January 2023 Department of Labor Relations decisions in case WMAS 229563, where discussion of this subject at any open meeting may have a detrimental effect on the Commission's bargaining position. Any discussion about this or questions for Todd? And if not, I'll take a motion.
Madam Chair, I move that we go into executive session for the reasons stated by General Counsel Grossman and yourself on the record.
Second.
Thank you. Discussion, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
And Commissioner Maynard.
Aye.
And I vote yes, 5-0. I want to just point out that the public session of the Commonwealth of the Commission's meeting will not reconvene at the conclusion of this executive session. It will be our lunchtime, and we have no other business that I understand from the Commission. Okay, so we will not reconvene in this public session. I want to thank everyone who's joined us today. The team, you did a wonderful job on some really new areas for us. So thank you, and thank you to the public who joined us. So I think we'll wait for, I don't know if Crystal is still navigating this, Executive Director.
I'm here.
All right, so we'll
Trying to push everyone in now. It should open in 1 second.
Yeah, we'll have to have that technical assistance transferred to someone for the time being. So,
well, our handy dandy Dave Souza is well able, and so is Mills. So we're good there.
Okay, everybody's been trained. Thank you so much. So, all right, everyone, thank you again, and we will go to the executive session. Thank you.
Rick, we'll move you over in 1 second there.
Okay.
Hey, Crystal, I'm not sure if you can still hear me. Rick Gello just joined. Can you move him over too, please?